This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why and how an insurer refused to submit to no-fault insurance fraud, and why a man-bites-dog story of an insurer defeating no-fault insurance fraudsters is something to honor and emulate. In State Farm Fire and Casualty Company versus 123 Medical Group PC et al., the New York Supreme Court, the trial court, on June 30, 2025, dealt with the request of State Farm for declaratory judgment that plaintiff, State Farm, was not obligated to pay no-fault benefits for the medical treatment of Darrel Branch, Andy Celeste, Marie Clermont, and Marie Merzier for injuries they allegedly sustained in a motor vehicle collision on February 12, 2024, based upon plaintiff's founded belief that the collision at issue was not an insured event, but was staged as part of an insurance fraud scheme. Plaintiff moved for default judgment against certain dozens of defendants, starting with 123 Medical Group and other healthcare or so-called healthcare providers. In order to establish its entitlement to a default judgment, plaintiff must submit proof of 1, service of the summons and complaint, 2, the facts constituting the claim, and 3, defendant's default in answering or appearing. Whereas here, service was effected on certain defendants via the New York Secretary of State is required to establish its additional service of the summons and complaint by first-class mail at these defendants' last known address. Plaintiff satisfied these requirements. It has also established that the additional mailing of the summons and complaint upon the corporate defendants has required notice of default with affirmation of mailing and defendant's default. While multiple filed answers between March 11, 2025 and March 12, 2025, those filings were timely rejected by plaintiff as untimely. Finally, plaintiff has provided proof of the facts constituting its claim through the affidavit of Mickey Fraley, an employee of the Special Investigation Unit of State Farm Fire and Casualty, detailing the basis for plaintiff's conclusion that the subject collision was staged. Accordingly, it was ordered, adjudged, and declared that State Farm Fire and Casualty has no duty to provide, pay, or honor any current or future claims by 123 Medical Group et al. And the rest of the named defendants, and multiple other healthcare providers, including but not limited to claims for mandatory personal injury protection, additional personal injury protection, uninsured, underinsured motorist coverage, and supplemental uninsured, underinsured motorist coverage in connection with the alleged collision of February 12, 2024. And it was further ordered that the plaintiff shall, within 20 days from the date of this decision and order, serve a copy of same with notice of entry upon the defendants upon the clerk of the court, who is directed to enter judgment accordingly. And it is further ordered that such service upon the clerk of the court shall be made in accordance with the procedures set forth in the Protocol on Courthouse and County Clerk Procedures for Electronically Filed Cases. In my opinion, insurance fraud takes no less than $308 billion a year from the insurance industry, and probably more. Insurers are required by law to maintain a Special Investigation Unit, an SIU, to investigate and work to defeat fraud. State Farm's SIU found detailed evidence that a series of healthcare providers provided services to people involved in a fake auto accident intended to defraud State Farm and cause money to be provided to healthcare providers who take a lien and claim falsely that they provided health care to the occupants of the car in the staged accident. Since the police fail or refuse to prosecute the healthcare providers, State Farm acted proactively to obtain a judgment that they do not owe the healthcare providers who are violating the no-fault law. And this is a wonderful and important thing for State Farm and other insurers to do, and should be emulated by all insurers faced with fraudulent claims. This video was adapted from my blog, Alma on Insurance, which is available free to anyone who clicks on the URL alma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll gain access to the more than 5,100 blog postings. You can also subscribe to these videos on rumble.com and on youtube.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.